We're on the record in People versus Scarborough. This is case number 235253.
Thank you very much, Mr. Scarborough. Mr. Scarborough just called my office. I just got a text from my office. He's about 10 minutes.
Okay, what are we doing?
So my understanding, Judge, is that Mr. Scarborough has tried to reach Ms. Gomez for a sobriety court. At one point, I sent him to Calcasta to the court. I said, just go there and make contact. And he's never been able to make contact, but he's completed the rehab, and was released from rehab. So I don't know what the court intends to do. The court did hold in advance the jail sentence because of sobriety court. And there's emails showing that he was accepted the sobriety court. I sent that to Mr. Haven as well, and I don't know why that contact fell through. But I know he's called. I've called Ms. Gomez a few times. I haven't received a call back. And then I know Mr. Haven has the jail credit time that he served so far.
Your Honor, at the time of his sentencing, he was serving in Wexford County for Calcasta.
Okay.
And August 21st, I believe it was, or somewhere in there, he was due to be released from before the shooting. At that time, from there, he did go to Bear River Health for a month of residential treatment, and he was released. But still, Stacy has tried to contact sobriety court over there. As Mr. Grimworthy said, he was sentenced to 9 months, held in advance for sobriety court, but not sobriety court. So I think that's what the purpose of today's hearing was to see where he was. In sobriety court, we could have canceled the hearing.
Gotcha.
So it's discretion to proceed.
Okay. All right. Well, let's see if Mr. Scarborough shows up first of all. Is anybody else that we can address?
Mr. Colcom's here, Judge.
Okay. People versus Colcom, case number 245324.
Mr. Colcom's a little sick. I don't know how close to one next over.
We're going to need to be able to pick him up on the microphone, so
We'll come sit here so I can stay up there.
Yeah. that'll work. All right, Mr. Grimworthy, can you tell me the status of this file today?
Yes, Judge. Judge, we would ask that you set this on the file docket, the cutoff date. We're going to try and resolve this, but so far the offer that's made is being rejected.
Ms. Coe, how much time do you think you're ready for trial?
You already in 60 days, Your Honor. I think we can do the trial in 1 day. That doesn't count. Call witnesses 2 days. We can do.
I think we can do this in 1 day. The only witness that we would likely call if my client decides to take the stand would be Mr. Colcom. We don't have to call the other witnesses. The people have already discussed.
Oh. So we'll set it for a 1 day jury trial. The court will set this for a motion. I'm sorry, a final status conference on motion day prior to the trial date. That will act as a motion cutoff. That'll also be a plea cutoff. So Mr. Colcom will have one more hearing before your trial, and that hearing will be on the last day to enter a plea if you want to consider it any plea offers further. Okay. That's your. Mr. Grimworthy, anything else I can address with your side?
No, sir.
Mr. Colcom, do you have any questions about how we're going to proceed with your case? Thank you. That's all for today.
I have two in jail that I might be ready on early. Sure.
Are any of them victim cases?
Yeah, that was. And law would be a victim case too. The police.
I don't know if there's victims that are prepared for court dates.
Right.
We send them out notices, we don't always know when they're gonna be there.
I'll talk to you. Okay.
Sir, can you tell me your name, please?
Andrew Parrish.
Mr. Thompson's covering that case.
So now I'm just in your, did Mr. Parrish get permission to appear by Zoom?
It says so on the
document. It says the prosecutor to appear.
Isn't this the one that says?
All of the parties.
Yes, it's a defendant on 989. Defendant to appear before the judge's commission.
Oh.
I'm not sure when he has, but I don't have.
The document there says.
All right. The record should reflect, this is People versus Parrish, case number 245317. Mr. Parrish is present by Zoom today. We have Mr. Thompson standing, Mr. Trush. This folks also present here. Mr. Parrish, do you have any objection to Mr. Thompson appearing on your behalf today rather than Mr. Trush?
No, I do not, Your Honor.
Mr. Thompson, can you tell me the status of this file?
Your Honor, there is a plea offer in this case. The plea offer would be for Mr. Parrish to plead guilty to possession of methamphetamine in exchange for the prosecutor dismissing the controlled substance second or subsequent offense.
Ms. Koch, is that a correct statement of the plea offer?
It is, Your Honor.
All right, Mr. Parrish, did you want to enter into that plea today?
Yes, Your Honor.
Have you had adequate opportunity to speak to your attorney, excuse me, to your attorneys about this plea?
Yes, I have.
Okay, can you raise your right hand, please?
Yep.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You can lower your hand. Mr. Parrish, are you currently on probation or parole?
Yeah,
Where's your probation? Is it, which one is it?
it's for Manistee, Michigan.
Okay, and is that probation?
Yes, Your Honor.
Okay, are they aware that you're entering into this plea here today?
Yes, Your Honor.
Okay, and has your probation officer indicated whether you're gonna face a violation of your probation based on this charge?
Yes, Your Honor. He's fully aware of that, and we've taken care of everything that's going to go on for it.
Okay, all right, and then I need to make sure you understand the maximum possible penalty on the charge that you're pleading to today, which is possession of methamphetamine. That's a felony that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. You have the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
What was that?
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to enter into this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Right, the information I have says that this happened back on May 19th of this year. Is that the correct time frame?
Yes, Your Honor.
At that time, were you present here in Crawford County?
Yes,
While you were here in Crawford County, did you have some methamphetamine?
yes, Your Honor.
Did you know that that's what that substance was?
Yes, Your Honor.
Did you have any legal right to have it at that time?
No, I did not.
All right, Ms. Coker, are the people satisfied with the factual basis?
Yes, Your Honor.
Counsel.
Yes.
Ms. Coker, are the people satisfied that the court has complied with statute and court rule in taking of this?
Yes.
Counsel.
Yes.
And Ms. Coker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Mr. Parrish, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. That hearing will be in person here in the courthouse in Grayling, so you'll need to make arrangements to be here for that date. In the meantime, somebody from the probation department here will be in touch with you for a pre-sentence investigation. Do you have any questions about that?
No, I do not.
Okay, Ms. Coke, anything further on this file today?
No, thank you.
Judge, we need his phone number.
What's that?
We need his phone.
Oh, Mr. Parrish, can you give us a phone number where you can, probation can contact you?
Yes, 906-450-5062. And if they cannot reach me at that number, I got another number. It is my parents' landline. It is 906-644-7191. If they can't reach me on my cell, they can call that number and let my parents know anything, or if I'm not at home or at work, I'm at their house. So
Okay, thank you. That's all for today, and you're free to disconnect at this time.
all right, thank you, Your Honor.
Okay, Mr. Dermott.
Mr. Scarborough is yours.
All right, we'll recall People versus Scarborough. Mr. Scarborough, come up to the podium there. Yes, sir. All right, so, counsel, I just want to, I know we discussed this case a little bit previously, but Mr. Dermott, can you just reiterate where things are at on that side?
I can, Judge. Mr. Scarborough pled to operating on the intoxicated third offense. The court sentenced him to 9 months withheld time in advance because he was making contact with sobriety court. I was in touch with Ms. Gomez for sobriety court. I shared those emails with Mr. Hayward that he had been in touch with her and that he was accepting of the program, and once the court sentenced him, that's where he goes. Since then, Mr. Scarborough indicates he's trying to make contact with Ms. Gomez and hasn't had any contact with her. And he's at one point went to the courthouse and she's never returned this call. And I've called police twice that I recalled to see if we can get him in there once that process goes. She hasn't called me back. And then Mr. Scarborough did go to Better River Health. I do have a certificate completion from there. I just checked with Mr. David. He has that same certificate, so he's aware of that. Mr. Scarborough indicates that he has some online meetings related documentation. That was the court notices.
Yeah, please.
He also has some additional documents here that indicate some of the groups that he has done. For example, the core groups 3 times for 23 hours per week, dealing with grief and loss, unresolved loss, and other court notice fees as well.
Yes.
So Mr. Haven has calculated based on the jail time he did and the time he spent at Bell River, total of 105 days. So I would ask that the board give him credit for the time and just continue with occupation. Mr. Scarborough indicates he is kept in touch with Mr. Haven, he checks in, and I would just ask that he continue doing that. Would continue. Jail and rules and regulations.
So, take any position.
Yeah, I have a little bit different feeling than Mr. Kaminsky. This court ordered me to sobriety for, I objected to sentencing, we had nothing in writing, they had ever been accepted in sobriety for, or they had done anything in sobriety for. Mr. Kaminsky had a 7-month-old email saying they'd review it. So we followed up after this court ordered him into sobriety court. I think at that time he might have been in Wexford jail. He bounced back and forth in jail for a while. Judge Day that said our sobriety court is on 8/8 met today. No one's familiar with Travis Scarborough. The team agrees that he has not been accepted into our program. We took him off the list a long time ago because there was no follow through. There's been no reason to communicate with Becky Gomez and our program coordinator. There must be another county involved and a different judge handling this because they're not waiting approval from me on anything. Or from ATS. So he was waiting for a release from Wexford. He got out of Wexford, never went into sobriety court, which is court ordered him into. That was the contingency for holding the 9 months in jail in advance. I guess he went to Bear River. He also has an opinion aggravated and that has been case from district court. We would just put them on. He probably should be ordered to do the time that he was ordered to. He never did the sobriety court program. And he was never in the sobriety court program. He was ordered into it, and basically had done nothing. I'd ask the court to just follow the sentence. He was, if he didn't turn himself in, ordered that he was to, or if he didn't complete sobriety court, he was to turn himself back in, I believe, and finish his jail time. Never did it in the first place. That's where we're, thank you.
All right. What's the status of this charge?
He was picked up on, he was arraigned on 9/20. Said aggravated DV.
September 20th.
Yeah.
Here,
Yes.
that felony. Mr. Haven, were you going to be doing show cause or a factual warrant based on that?
The behavior happened, he had failed to show up for sentencing back in March.
Right.
The date of the offense was prior to his sentencing year, so it would be a violation.
Okay. Do you have, or can you get me a copy of the original pre-sentence report? Yeah, I'm gonna take a short recess. I want to read through the file, the original pre-sentence report, so.
And Judge, if I could just for the record, the email I received from Ms. Gomez indicates perfect, the team agreed that we allowed it. And since then.
That was in December, right? 7 months before 17.
Yes, it was in December. So he is, again, trying to reach out to her, and if she hasn't called me back. I don't know where the disconnect is, and like I indicated, I've tried to do the same thing. I don't know. But
I call her, there's no answering machine on her number. I went up to the courthouse and told Casco to make sure I had the right number. They gave me the exact same number, you call it, the answer, the answer machine, the message. And I've been trying to call her since I was in rehab. I called my counselor, let me make phone calls to her to try and get her rehab. And I can't get into a program when I can't contact her. I have tried several times, probably 15 times to call her. And the number never picks up. There's no answer machine to leave a message. I mean, I had my phone on, I can call it right now. There's no answer machine, no. There's no way to get a hold of her.
And I tell him, but I did tell him at one point, why don't you just go tell Casco, go to court, go there, see if you can make contact. Which he did. He verified whether the number he had was the right number, which it was.
So it's right on the back of my car for
So
Ron.
I do know that at least at that point, he did follow my advice and go to the court to make contact with him as well. So
I mean, I don't know where that disconnect is coming from. I can tell you that county circuit, and all those counties we deal with Ms. Gomez, or the strategy court. You're the first person in all that time is telling me that she hasn't never called back.
I'm,
So I don't know where the disconnect's coming in. All I can tell you is it's not a problem I've ever had. So it's trying to be open for 7 months.
I haven't been trying since I got out of rehab in August. But from August until now, and I call this number, I almost got it memorized, I call this number. 221.
Well, it doesn't matter because the fact of the matter is, you're not in sobriety court, you're not going. to be in sobriety. So now we gotta figure out here or do that. What steps. So Mr. Gerber, you would, Mr. Scarborough back up, report of recall people versus Scarborough. All right, so Mr. Scarborough, I had a chance to review the file, original pre-sentence report. I had a chance to go through the, or actually review the sentencing. Yeah, case, I myself there. What everybody said and where we were at, and it's clear after reviewing everything that you know the jail time being held in advance was your participation was dragging forward. It's going to happen. So at this point, the court is going to remand you to the jail to serve your sentence. Although it wasn't part of the agreement or what we mentioned at sentencing, I do think you should get credit for the time that you were in treatment. That you think that's a positive thing. So the court will give you credit for that period of time, that sentence. In total, it's 105 days.
That's what Mr. Haven calculated. I agree with that as well. Mr. Haven would confirm that. We agree.
Okay. All right. And then all the other provisions of the sentence will remain in place. So, point to the custody account.
Judge, I know Crawford County doesn't do any work with this. I don't know if you would serve in another county, if you could do work with his employers here. Mr. Scarborough has maintained employment. You wanted me to bring that up next. I've indicated Crawford County doesn't do that. So I don't know who has any thoughts on that.
I really don't. I'm open to whatever gets presented to me in the future, but at this point, Crawford County is something that's
My job is up there, county,
right.
You want to take that? Thank you.
Are we ready on Mr. Beck's case?
The only issue is I don't have appellate paperwork for Mr. Scarborough, so I just looked at the record. We did go over that at his prior sentences, so he does have his reason.
Correct. Yes.
I'm ready, Mr. Beck, yes.
People versus William Beck, case number 245313.
Here, over there, for people.
Begins. My understanding is that we have an agreement for.
Correct, Judge. In this file, 5313 of H, Mr. Beck would plead no contest to the rest of the offense. It's a 5-year felony. Mr. Beck, I was arraigned yesterday on a criminal sexual conduct. That's when we dismissed this one.
I'd be fine.
Right, that's a correct statement of the plea.
It is.
Okay. Mr. Beck, have you had an adequate opportunity to speak with Mr. Gerber about this? Is that how you wanted to proceed today? You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth to help you God? Lower your hand. Are you currently on any kind of probation or parole? No. And as Mr. Gerber indicated, the maximum possible penalty that you can face for this charge would be up to 5 years and or a $5,000 fine. That in mind, what is your plea to that charge today? No. Right, and you understand that for purposes of sentencing, the court treats a no contest plea the same way that it treats a guilty plea. Has anybody threatened you with anything to get you to plea no contest? Everybody promised you anything other than what you said here in court today? Is it your own free choice to enter into this plea? Yes. By entering into this no contest plea, you're going to be giving up the same rights that you'd be giving up if you pled guilty. And I'm going to go through those rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court ordering witnesses on your behalf if you're at trial. You have the right to remain silent during the trial, to not have that silence used against you, and the right to testify at the trial yourself if you want it. You understand that you have all those rights.
Yes, sir.
And you understand that you're giving up and waiving those rights by pleading no contest.
Yes, sir.
If anybody forced you or threatened you with anything to give up your rights.
No.
All right, Ms. Cope, have you reviewed the police report in this case? It's Michigan State Police Report Incident number 7210994.
Sure.
Do you agree that it would provide a factual basis for finding you guilty of count one?
Yes, Sharon. Basically, if it gets to prior support. Not sure if that can be.
Mr. Kirby?
I would agree as to the police report as to the fires for the expert purposes. And the reason for no contest rules, the deviations as the police report would indicate that. This is
Ms. Cope, you don't have objections to no contest.
No.
All right, the court will mark that police report that I've identified as court exhibit 1 and admit that to the file as a factual basis in this case. Ms. Coke, are the people aware of any threats, promises, or inducements other than what's placed on the record?
Now we are dismissing 24. We're dismissing some of this report. Other than that, no.
no, Judge, and I would like to just present the bond.
Ms. Coke, are the people satisfied that the court has complied with statute and the court will take it in civil contest?
Yes, Sharon.
I agree to it.
Okay, Mr. Beck, the court finds your plea is knowing and voluntary. The court is satisfied based on the information in court exhibit 1 that there is a factual basis in support of finding that you are guilty of this charge. The court will accept the no contest plea. Set this matter for a sentencing hearing. Will be notified of the date and time of that hearing. Let's go. Mr. Gerber, yes, the bond.
So Judge, in this case, Mr. Beck already posted my law just as the bond be continued. Since the other case is going to be dismissed, the bond that was sent in that case no longer applies, so it shouldn't be disputed.
Ms. Cope, do you have any objection to bond in this case?
I'll do that now, this afternoon.
And certainly the pre-trial release orders with no contact, all those will continue on this case. So he's
Right, yeah, you're gonna continue to be under the same bond conditions. All right, the only other thing, Mr. Beck, just make sure that you stay in touch with Mr. Gerber prior to the sentencing. Okay. Thank you.
thank you, Judge.
Mr. Vernon, are you ready on Mr. Check? Versus checks. This is case number 235302. Yes.
That was drafted that it's going to be no contest plea. We're going to adopt the police report. The cover pages for the first page is the factual basis for count 1. There's a paper clip attached on the side. And that's the factual basis for the second count. Down at the bottom, it's that bottom sentence plus this first sentence on the next page.
And these are being done under referrals or different referrals. The attempt RNO is going to be under the 771 delay. The DD is 7694A. We did consult with the victim. She is okay with this. He has no criminal history. We wrote this in the way that it's supposed to be done in this report. For the report, it will be attempt to count one instead of an added count. We just do it differently.
So count 3 and then attempted count 1.
Yes.
It's the only difference between what the written plea offer states and what they're actually.
Yes. Procedural.
We acknowledge distinction, waiving, reading that might be required.
And Mr. Vernon, what would be the reason for the no contest?
Civil liability in both cases.
In this code? You don't have an objection to the no contest? Mr. Checks, have you had an adequate opportunity to see the hearing device?
No, I just definitely see.
Oh. All right. Have you had an adequate opportunity to speak with Mr. Vernon about this plea agreement?
Yes.
And is this how you want to proceed today? Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can lower your hand. Mr. Checks, are you currently on any probation or parole? You understand that the maximum penalty you could face for attempted resisting or obstructing is up to 1 year in jail? And the maximum possible penalty for domestic violence is up to 93 days in jail and or a $500 fine. You understand that?
Yes.
With those maximum penalties in mind, what is your plea to each of those charges today?
No contest.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights,
Yes.
and you understand that you're giving up and waiving those rights by pleading no contest. Is anybody forcing you to give up your rights today? Has anybody threatened you with anything to get you to plead no contest? Has anyone promised you anything other than what we've said here in court today? Is it your own free choice to enter into this plea?
Yes.
Ms. Coe, have you reviewed the Sheriff's Department reports here? And by that, I'm referring to a witness statement that was given as part of this incident.
Yes.
And it's on July 16th. This year, yeah, that's all included within Crawford County Sheriff's Department, case number 24120000959.
Yes.
You agree that the information within that report, specifically as identified by Mr. Vernon, would provide a factual basis?
Yes.
Mr. Vernon, would you agree with that as well?
I would, the two provisions that I identified to you would not necessarily identify venue, but we would stipulate the events for Crawford.
Okay. The court is going to mark that report and witness statement as Court Exhibit 1. The court will admit that as the factual basis in this case. Ms. Coke, are the people aware of any threats, promises, or inducements other than what's been placed on the record? Mr. Vernon, are you?
I like that, I know.
Ms. Coke, are the people satisfied that the court has complied with statutes and court rule in the taking of this plea?
Yes, ma'am.
Mr. Checks, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis based on information in Court Exhibit 1 to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. I'm sorry, no contest. Thank you. The court is going to set this for a sentencing hearing. You'll be notified of the date and time of that hearing. Mr. Haven, we could just have a misdemeanor PSI prepared for this.
I'll meet with them and give them the information.
Do you have any questions, Mr. Checks? Okay, thank you. That's all for today.
Thank you, Judge.
All right, People versus Bradford, case number 235202.
There are a couple of people.
Mr. Bradford is here. Did get two letters. We have Mr. Bradford this morning.
Okay.
I've given copies. I would ask that that be attached to his consent.
Give me just a moment.
Yes.
Okay, I had an opportunity to read that letter and report that with the pre-sentence report. Mr. Bradford, have you had a chance to go through the pre-sentence report with Mr. Germer? Need more time to do that today before we go forward?
I am.
Would you like some more time to go through it with him before we have the hearing? Sure. We'll pass that matter for right now.
Because that's not till 11 and Ms. Shady indicated that she can get it out. She must get some.
Are you representing Mr. Bowman?
I am. That's going to resolve it's a victim case. East Shady. If you want to take Ms. Crossman, she's here.
Well, let's take a short recess and then I'll give you a chance to speak with Mr. Bradford. We'll come back on the record in 10 minutes. Back on the record, Mr. Bradford, have you had a chance to go through that report now?
I have.
Mr. Murphy, are there any additions or corrections?
No,
Any challenges to the scoring I've got?
no,
So, do people have any additions or corrections? Challenges to the scoring? Do you have any victims that wish to address the court today? Anything on behalf of the crowd?
I did read the letter saying, and I want to address that first. This case was adjourned a lot. That was on defense request. Never adjourned on my request. So all of those adjournments were attributed to the defense. I say that because they read it there that that was a major issue in this case. Well, that was the defensive issues. The restitution amount is $57,259. So it wasn't because of the hurt finger, which was implied in here. The officer that was involved in this had to have a major surgery on his shoulder. They had to go through the response and follow all of those steps. He just returned back to work. He was out of work for almost a year as a result of this. So the way this letter is written, I think doesn't understand the facts of what happened in this case. I think the recommendation is appropriate, and I'd ask the court to follow it. Thank you.
Thank you, Judge. So by way of delays or defense, I was not Mr. Bradford's attorney to begin with. This case was dismissed here. So I was appointed at the final pre-trial. The case was set. It was the only adjournment we asked for this on the day. Since then, the staff was on the additional adjournments that were requested. I don't know what happened prior. I don't know what conversations happened, because I can't comment on those. But what I can comment is, since I represent Mr. Bradford, where and what my direction of Mr. Bradford, they're being appropriate with him, is engaged in therapy, is taking his meds and he's got his medication and is properly diagnosed to have medications. At the time of this incident, he was on his meds in that proper diagnosis. And even prior to that, while the case was pending, I didn't have any of those things in place. Since then, he's done just fine. I think the important part of all of this is Ms. Anderson's letter that she indicates that he was 100% in compliance while on police orders without any violations, checked in, didn't violate his bond conditions. So those delays, even if it applies, he was on those bond conditions for a very long time and complied with them. What that tells me is that Mr. Bradford, if medicated properly and is in therapy, which he is able to understand and function without having issues. Those are the highlights. Mr. Bradford's 36 years of age, has some close head injuries. And then again, at this stage of his life is on the right medication. So I really hope that we don't see Mr. Bradford because this incident, nobody wants this to happen. Mr. Bradford has told me he's very remorseful. He's seen the videos. I don't think he's had that out before I was with him to understand the seriousness of where and why, and how this ended up, and why it was in the position it was, and how somebody could be hurt. It could have been worse. He certainly doesn't want any of that. So he's very remorseful for his conduct. Mr. Bradford is not challenging restitution either, because this is not, again, the letters were not written by him, they're on his behalf to get it. You know, he's got family support. Mr. Bradford is not challenging that. He understands that being a delivery driver at Jimmy John's, not something that he makes a lot of money doing, even for a year. He can be an appointment. He's going to be making payments for a long time to make the victim whole. And that's his intent. It's not to challenge it, not to delay this, not to, his intent when I began representing him was not to go to trial, was to resolve this case. That's why at that short time, we were able to resolve it. The case was jumping multiple times. But I can't comment on this. I can only comment on again where we were and the time frame we got this done. I think it was about a 6-month time frame, which is both of these cases. So I don't want Mr. Bradford to be punished for those reasons. We had some issues understanding why where this case was, understanding his documents. Mr. Bradford knows that he's likely to get jailed today. He understands that he may be incarcerated. But he's asking the court to not go to the 9 months that's being recommended, but consider something like less, so he could have the opportunity to present to the court that he is able to continue working, continue work and pay his restitution, working based on it. That's his main goal. I don't think, again, in conversation with me, he's not worried about the jail sentence, he's worried about how do I prove that I'm able to be a functioning member of society. I can go back and do all these things. I want that opportunity. So we're asking the court to deviate downwards from the recommendation, and not to give me an opportunity that he's desperately asking for. And again, when we look at why he was on bond, he's able to function and comply with this. So I think he's able to do all those things. He's got his medications to take him to jail today. So I would ask that the court to craft an order where if he gets some jail, he understands he's going to get it, the court to read in advance, he's able to do the things he's indicated he wants to do to make feel as though he's complying with the terms of being a member of society, not a member, and they. So that's what I'm asking.
Mr. Bradford, anything?
I've been at Jimmy John's up in Gaylord for a year now. I'm almost all day, every day. Like last night, I get filling all the time. I never tell them no. Not that actually. I'm usually just a delivery driver or a janitor. The janitor jobs would be done for me because so those jobs will be on, but I really like being at Jimmy John's. I don't want to leave. That's it. So I'm there usually all day, every day. When I come home, I try and help my dad out as much as I can. Now, once you're coming, really needs to help. So it's not keep the ice there. So yeah, my worries are more everywhere else. My worries are on everybody else. Absolutely, I do want to apologize. I didn't mean for any of this to happen at all. If I had these at the time, never. I'm in therapy, doing everything I can to be better. Therapy, doctor plans medications, like the attorney said, I've been compliant with everything. Trying to prove myself, like you said.
All right, I did read through the report, familiar with what happened in this case. There's also a lot of information in that report about your background and your industry and circumstances. Certainly take all of that into consideration along with what the lawyers had to say and yourself here. I did read the letter. I'm not going to put a lot of stock in that letter just because I think it's written from a perspective that's just clearly not connected to the reality of the situation. And I, number one, it's helpful to you. Number two, it just doesn't represent a realistic view of what's happened, what did happen in the circumstances. I do, however, place a lot of stock in police reports and descriptions of your conduct during this incident, which did place yourself and a lot of other people in danger. It's gone in a lot of different directions that could have been a lot worse for everybody involved. As it is, you engage in serious assault conduct towards members of the household, and then, of course, say nothing of law enforcement that showed up at the request of people at your house. They weren't just driving around looking for something to get involved in. 911 call was made and they came to respond. They're doing their job. And what they faced when they got there was really unfortunate and resulted in what I consider to be a considerably serious injury to one of the officers. Rotator cuff, nothing to trifle with, and it's a serious surgery that takes a lot of recovery. So I think your conduct needs to be viewed for whatever reason that it occurred, whether it was mental problems or lack of medication, needs to be viewed in the context of people who are there trying to use that situation to deal consent state that you read this harm. And so for those reasons, I do think that significant punishment is appropriate in this case. We'll press upon you that this conduct is not going to be tolerated, and also as a deterrent. So that see, if you're going to fight with police, injure police who are just again they're responding and requesting people trying to help. That's going to be not a serious consequence. So I do think a combination of jail and probation is appropriate. Probation is, I think, necessary to provide some supervision to make sure that you're continuing to follow through with any treatment, medications, and so forth that you need to make sure that you're in a mental place that you're not going to be susceptible to engaging in these kind of conduct. And I think some punishment is necessary again for the reasons that are stated. The court is going to place you on probation for a period of 2 years as recommended. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to order that you serve 12 months in the Crawford County Jail. You have credit for 2 days served. And I think that sentence is necessary for punishment as well as deterrence. Crime victims assessment of $130, supervision fee of $30 per month, $30 per month while you're on probation, $325 court costs, $350, DNA testing fee of $60, $68 state cost. That all relates to the criminal charge. That's the domestic violence charge. 93 days in the Crawford County Jail, credit for 2 days served. Serves concurrent with the other sentence. $50 state cost of that charge. And then restitution. So correct that.
The restitution amount is $57,259.44. Crawford County, and then provided in the sheet.
Without that, it's restitution. Mr. Bradford, you do have the ability to seek an appeal of the sentence.
Yes, Judge, I did go over Mr. Bradford's account paperwork. He has this copy.
Judge Court says.
That's all for today, Mr. Bradford. You've already discussed the People versus Crawford, case number 245320. Record to reflect Ms. Strasburg's present.
Here goes the other people.
Feeling, you know, we have to response issues there.
This is the date and time set for sentencing this matter. Ms. Strasburg, have you had an opportunity to go through the pre-sentence report and talk?
Yes.
Ms. Toth, do people have any additions, deletions, or corrections? Any challenges this morning? Do you have any additions?
No, sir. No.
Ms. Toth, anything on behalf of the people?
The recommendation for 2 years probation, and then the first charge, 2 days, 2 days credit. And for the AMU, 5 days is required by statute, for 2 days credit. So they ask the court to adopt that.
Ms. Strasburg has very minimal prior criminal record of arrest and a felony charge of greater than 74 level status, and allow her to comply with probation. Proof to the court that she's entitled to at the end of this probationary period for dismissal of this felony. Again, while on bond, she was given some compliance and issues. As it relates to the OWI charge, I think Ms. Strasburg, the statute requires mandatory 5 days, 2 days of close have to be done before the year. She's done that. Court really doesn't have much of discretion in not sentencing her to those 3 days. Ms. Prosper doesn't really have an issue with the 3 days, but she's asking that she be allowed to do it after the 16th of next week. She is on medication, she's got medication tubes, which I don't think the jail allows. She's been on these medications for 25 years. And she gets these bottle prescriptions filled on the 16th, which is a Wednesday of next week. So she can go herself on either Thursday or Friday and have the 3 days done. So that's what she's asking for. Otherwise she's not going to be allowed to do those events. It's going to create medical issues for her. She can explain all the different medications that she's on. She's indicated she's on those for about the last 25 years or so. So she doesn't know what she doesn't have a bottle prescription for. So she needs to get those appointment with her provider is still the 16th next week. So
Which care, my doctor, they moved me to a different doctor and my appointment was in September, but I'm sorry, not in September. It was scheduled for October 2nd or 4th. And then they called and the doctor had a family emergency. So they moved it to November 8th. So they got a hold of a bridge care doctor to take care of me until I can go see the doctor on my original doctor to be able to fill my medications properly. Because they haven't been able to because my appointment on the 4th got messed up. And then I won't be able to have that new appointment till then. So they have a doctor, Brian McCauley, to see me on the 16th next week.
That's Wednesday?
Yes.
So what's gonna happen?
She's got these little tube medications.
Yeah, I have a weekly box that I had I have my meds in for this week, and then I have one at home for the beginning of next week. I just don't have the actual prescription bottles.
So I understand that since it's not a prescription, it's just loose pills.
And I have it in my purse.
The jail won't allow to take that.
How did you know?
I have to have them in the original bottles, I don't have them because of how they've been switching me back and forth from different doctors and stuff.
If the jail allows it, I don't need that.
Yeah, no, I mean, I have enough for the days I need to be in there. I think that you have to have them in original prescription bottles, that's what.
We're gonna look into that.
Okay.
Ms. Strasburg, I usually don't let people report later for jail. Bad things tend to happen between sentencing and they need to report for jail.
Okay.
So we're gonna check into the bill issue. If it's something that's life-threatening condition. Like your health in danger for 3 days of jail, but if it's not gonna be a problem, it needs to be that serious. Like report on a later date. So we'll check into that, but
Okay.
Mr. Grimmer,
I was just gonna see if she wants to pull that out, so.
Oh, yeah.
I don't think we need to go through all that
Okay.
right now.
Okay.
I'm just gonna talk to the jail administrators. Any further out?
No, nothing on behalf of Ms. Fossil with that issue.
Ms. Strasburg.
Other than that, I already know that what I've done was wrong and that I'm willing to do anything I need to make it right.
All right, I'm glad to hear you say that. It didn't come through in your statement in the report.
Oh, yeah.
Your statement sounds like, you know, you didn't really feel like you did much wrong.
No, I know when I did wrong.
Regardless of substances, driving in impaired condition.
Correct.
Put yourself at risk.
And other people too.
Yeah, a lot of innocent people that don't have any condition.
Exactly.
At one time, Lieutenant, I did call the jail, talked to the corporal. They did confirm that unless the prescriptions are in the original prescription bottle, they will not.
Okay, so, yeah, this is, I have to take this situation very seriously.
Yes.
And we're gonna have a period of time where for your supervised probation. And I hope that that goes well. I am going to impose a significant sentence, and that can make you serve that up front. Because you really don't have a prior history. This was a non-assault crime. But to the extent you don't comply with your probation, I want to be very clear that there's not going to be a lot of room in terms of your. I'm going to have no trouble imposing the jail time.
Understood.
Aside from that, avoiding having to serve significant jail time, there's also a benefit to you regard to the felony set aside statute 7411 that will allow this record to be successful. So there's a significant upside to you getting your arms around this line of probation. Downside. So the court is going to, with regard to the possession charge, where it's going to sentence you to 2 years of probation, pursuant to 7411, or it's going to adopt this condition for that probation, all the terms and conditions. Each report, which your probation agent will go through with you. The court is going to impose 6 months in the Crawford County Jail, and that charge with credit for 2 days served. The court will balance of that time abeyance. The court is going to order a crime victim's assessment of $130, unity testing of $60, $68 estate costs. As to the operating while impaired charge, the court is going to order again 2 years of probation. The court is going to adopt as the conditions that probation, all the terms and conditions listed in the report. With the addition of the $30 supervision fee, the court is going to, while you're on probation, the court's going to order a $325 court cost, $350 $50 state cost. And that file, as to that file, the court is also going to order certain 93 days, 1 year, 6 months in Crawford County Jail. You have credit for 2 days served, what's going to order to be served 5 days of that up front. Court will allow you to report to the jail on October 17th, serve those 3 days, and that's served consecutively, starting at the 17th of the night served, or to report to the jail by 9 a.m. on October 17th. You do have the ability to see the appeal of these sentences with your review. Right.
Because I don't believe it should be a otherwise once in the total of some sounds to me. So I did not go over those with her because I don't believe she has those on the sentence.
Spoke anything further from your side?
Thank you.
No, sir, thank you.
Ms. Strasburg, do you have any questions about when you need to report to the jail?
9 a.m. on the 17th.
If you fail to report by 9 a.m. on the 17th, report the relation.
I will be there.
All right, thank you. That's all.
Thank you.
Were you ready on Mr. Moore's case?
I want to check and see if Ms. Moore is here, Judge. If she's not, I probably would like a motion. But let me see if she's here.
Mr. Law. Morning.
All right, let's go on the record versus Jessica Moore, case number 245320. This case was set for hearing at 10:15 and 40.
No, Judge, I haven't seen Ms. Moore in the hallway. I I did walk around and call her, she wasn't there. I just want to confirm she's not on Zoom.
No.
Okay. I did indicate from the other person, so she's not here, Judge. I think at this point, I can't go forward with my motion. I just have to be fine. She's not present here.
Okay. The court will consider the motion that's set for hearing today withdrawn. Absolutely non-appearance.
Your Honor, it was their motion. I don't know how they got notice to work in the center or something. Condition. Sheriff was here to go with the inventory policy of the court. I released him from subpoena. Thank you.
This is also set for a status conference today to be held in conjunction with the motion.
It was.
I don't see any other here at this more, so the court will set this as a show cause status conference for the next available date. If she fails to appear at that time, we'll call. Yeah.
Oh,
Okay, we'll be in recess until Mr. Judge. We're on the record and versus Gentilla, this is case number. All right, this is file number 245318 and 245331.
Here for the other people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Justice Gentilla. Your Honor, we do have a verbal resolution, resolve all claims in both files as well as ask for some potential case.
Can you tell me the terms of the agreement?
Yes, Your Honor. In the 9-count case, Mr. Gentilla, counts 3 and 5. Those are both associated to agent lack essentially.
Okay.
Those are both SORA tier 2 offenses, they're both felonies, punishable by 4 years and for $1,000. All other counts would be dismissed. In the other case, the 2-count case, and count 3 now, it's going to be the same statute, same offense, constitutional minor lack. Counts 1 and 2 will be dismissed. In addition, the prosecutor investigated a potential third case relating to images from Mr. Gentilla's phone, seized computer, and has agreed not to pursue charges to pursue that charge.
Scope.
That is a correct statement of the law. I'm just going to make a record. We dumped his phone to the computer crimes unit. There were lots of photos on them. I actually sent them to a doctor in Grand Rapids. She had personal tragedy. Her son died. During this, so it took a little bit longer to get the answer. She reviewed the records, and we agreed that did not feel like it proved beyond reasonable doubt that pictures for somebody under the age of 18, and therefore not going to pursue those charges. And the statements put on White and Temple as the offers are correct.
Right. Mr. Gentilla, have you had a chance to speak with Mr. Thompson about this agreement?
Yes, Your Honor.
And what we've discussed here today, is that what we discussed with him in the past? Do you need any more time to talk to them before we move forward with it? Do you want to accept this with the offer? Raise your right hand, please. Did you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God. Mr. Gentilla, are you currently on any kind of probation or parole? Ms. Koch or Mr. Thompson, are you aware of any mandatory consecutive sanctions that arise on these charges?
No, and if I could add to the plea that I put up the record, there is a provision for enhancing and a costing charge. These are enhancements.
All right, and Mr. Gentilla, as your lawyer indicated previously, each of these charges carries with them the maximum possible penalty of up to 4 years and or a $4,000 fine and registration of the sex offender registration list as a tier 2 offender. You understand that? Yes, sir. With all of those potential consequences in mind, what is your plea to each of those charges? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during that trial and to not have that silence used against you, and the right to testify at a trial yourself if you want to. Understand all of those rights. And you understand that you're giving up and waiving all of those rights by pleading them. Also, you don't have an automatic right to appeal the plea that you're making today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, the Court of Appeals, so hear your case. They could say no, and then that would be the end of any appeal. Understand that? Has anyone threatened you with anything to get to the appeals? Has anyone promised you anything other than what you said here in court? Is it your own free choice to enter this plea? Are you pleading guilty because you are guilty of each of these charges? Mr. Thompson, I'm gonna ask some questions.
Mr. Gentile, in early 2024, did you engage messaging through your telephone? It's on page 18. Yes. Through different individuals. All right. Can you read those conversations? Right. Do you agree that in those conversations, solicited, requested, those minors engage in those inappropriate conversations? Conversations around a certain nature. All right. And you agree with those constitute costing of minors and no more than the Crawford County, Michigan.
My only question is this, the statute references under 16. Would you agree with that?
Is it a child from the age of 16 that you can, under 16, that you can establish that for the vision?
Yeah.
All right, those are the age of 16.
Yes. Ms. Cope, with that, are you satisfied with the actual basis?
I am.
Thompson, are you?
Yes.
Ms. Cope, are the people aware of any threats, promises, or inducements other than what's been placed on the product? Thompson?
No.
Ms. Cope, are the people satisfied that the court has applied the statute?
Yes, Your Honor.
Yes,
Mr. Gentile, the court finds that your plea is knowing, voluntary, and accurate, or is satisfied based on your testimony here today that there is a factual basis in support of finding that you are guilty of each of these three charges. The court will accept your guilty plea as to all three. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, you'll be put some information card for a pre-sentence report. And then prior to the sentencing hearing, you'll have a chance to read through that and talk to Mr. Thompson about that. Mr. Thompson, anything else that you need to address?
nothing further to the record. Thank you.
Until any other questions. Thank you, Ms. Hull.
It is, yes.
Yes, usually none of them are second.
Yeah, that's the case. I was just saying, that's my
I actually don't.
Just leave them.
The Mr. Moore.
So we're just waiting for Mr. Watt to be brought.
We're just checking.
We're on the record in People versus Law, case number, district court file number 2417615-1. The court is sitting on this case by assignment. Mr. Law is present here at the courtroom today. Counsel, go your appearances on.
Yes, Your Honor, Dana Cheney on behalf of the people.
Hey, I don't have to go with Mr. Law, who's just.
Mr. Germer, do we have a complete resolution at this moment?
We do, Judge, we have it down to writing and I'll present it to the court. My client will be pleading no contest to count 1 to potential civil liability. Counts 2 and 3 will be dismissed. And Mr. Law will also be given 769 for deferral treatment.
Mr. Cheney, is that a correct statement? Yeah.
Yes, Your Honor. We have had consultation with the victim and permission. Thank you.
No objection to the 769 for deferral.
That is correct.
All right. Okay. Mr. Law, have you had an opportunity to speak with Mr. Germer about this agreement?
I have.
Okay. And what we've discussed here today, is that the same agreement that you talked about?
Yes, sir.
Is that how you want to proceed?
Yes, sir.
Now, you can't raise your right hand, but you solemnly swear or affirm the testimony you're about to give, believe the truth, the whole truth, and nothing but the truth. So, yeah. Yes, sir. Mr. Law, are you currently on any kind of probation or parole?
No.
Can you understand that by pleading guilty to count 1, that despite whether or not that's placed on a deferral, that the maximum possible penalty under statute for that domestic violence is up to 93 days or a $500 fine?
And Judge, there's no contest.
Right. Yep, I'll probably mess that up at some point. Mr. Law, what is your plea to that charge?
No contest.
I go through your rights with you. These are the rights that you're going to be giving up by pleading no contest in this case. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes.
You understand that you're waiving and giving up all those rights by pleading no contest? Yes. Has anybody threatened you with anything to get you to plead no contest in this charge?
No.
Has anyone promised you anything other than what we said here today in court?
No.
It's your own free choice to enter this plea.
Yes.
I've been provided with Crawford County Sheriff's Department report number 241201114. I've reviewed that report. Ms. Cheney, you reviewed that report.
Yes, Your Honor.
Would you agree that the information in that report would establish a factual basis for a finding of guilt as to one?
Yes.
Mr. Gerber,
I would agree with that.
the court will mark and admit that report as court exhibit 1. Ms. Cheney, are the people aware of any breath promises or inducements other than what's placed on the
No, Your Honor.
No, sir.
Ms. Cheney, are people satisfied that the court has complied with statute and court rule and taken this no contest?
Yes, Your Honor.
I would agree.
Mr. Law, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied based on the information within court exhibit 1 that there is a factual basis to support finding that you are guilty of count 1. The court will accept your guilty plea. The court will set this for a sentencing hearing. You'll be notified at the time of that hearing.
It's
I
going
can't
to
give you the, what's that?
Oh, I was just saying if I could address bond.
Yes, I can't give the date of that hearing today. So I'll work it out. My staff of this report. That's the bond.
Judge, the city is going to withdraw this was the bond petition that was filed. I would ask that his bond be reinstated. Mr. Law would continue with the pre-trial release orders that he has in place and not violate and have contact with the computer release.
Yes, Your Honor, the people will do that. The people have filed an expert motion. Second, for the bond violation. So at this time, please.
Okay, so the court will reinstate Mr. Law's bond. But Mr. Law, you'll continue to be subject to all the terms and conditions of that bond as discovered. You violate the bond, you violate the vote. Anything further on this case, Mr. Chair?
Your Honor, I apologize, just factually, since we haven't done the state bond on the reinstating the.
No, I'm reinstating the bond as previously set, posted by Mr. Law, so he doesn't have to make additional, he just needs to comply with.
Thank you, then other than that, nothing further from the people. Thank you, Your Honor.
And Judge, I know Ms. Norman's here, so she's gonna meet with Mr. Law regarding preparation of the precinct. At least for district court, it's no.
All right, very good, thank you. That's all.
Thank you.
He comes to you.
Okay, sir, are you Mr. Gilder? No.
Mr. Law's there.
Oh. Okay, we're on the record. This is Olson versus Gilner, case number 2311313. The record should reflect Chief Gilner's present here before me today. Council.
Chris Mertz here on behalf of Mr. Wilson.
I have the set for a better exam today, so that's usually what I do is just place the individual under oath. So Mr. Gilner, raise your right hand. Do you solemnly swear or affirm that testimony you're going to give today and the answers in any documentation provided to counsel for the plaintiff will be the truth? Do we have anything else?
We don't typically close the courtroom, but there is a conference room out in the lobby or downstairs too as well.